The request was rejected by Pelosi, by congressional leaders, including requests, by the way, from the Capitol Police Chief. Here with reaction, author of, it's in bookstores everywhere, Amazon.com, Hannity.com. I read the book cover to cover. It's worth, you got to get a copy. It's an insider's view that actually is fair to Donald Trump. What a rarity. The Chief's chief, Mark Meadows. First, I guess I'll get your reaction to the January 6 vote 9-0 to now go before the House. But we already know this is a predetermined outcome. Didn't we learn that when they kicked Jim Jordan and Jim Banks off the committee?
Well, we did. Obviously, it's disappointing, but not surprising. And let's be clear about this, Sean. This is not about me holding me in contempt. It's not even about making the Capitol safer. We see that by some of the selective leaks that are going on right now. This is about Donald Trump and about actually going after him once again, continuing to go after Donald Trump.
Mark Meadows started out in trouble, and now he's in even more trouble. If you don't know who Mark Meadows is, he's an associate's degree holder who became the chief of staff to the former President of the United States, Donald Trump, in the last months of his term. He was indicted by the Fulton County District Attorney, Fani Willis, on RICO, or racketeering charges, for participating in an extensive conspiracy to overturn Georgia's 2020 election results, according to Willis's office. This trial of 19 people, of which Donald Trump and Mark Meadows are two, is slated to be tried in Fulton County, which includes Atlanta. This is a problem for Meadows and all 19 of his alleged conspirators because of jury selection. The jury in this case will be drawn from the Atlanta metro area jury pool, which consists of an electorate that Trump lost by 75%. However, if Meadows could get his case removed from the state court to the federal system, he would then get a jury selected from 10 adjacent counties who voted against Trump by 65%. This 10% difference is not insignificant at all, as Meadows needs only one juror to hang the jury, so this 10% difference can be large. Furthermore, moving the case to federal court provides Meadows with a number of other advantages. First, if Trump is reelected, even if Meadows was convicted with a federal conviction, Meadows could receive a pardon. A conviction in state court, however, has no federal redress. Furthermore, even if moved to a federal court, the charges would still be tried under Georgia law by the Fulton County prosecutors. However, federal court judges may be less likely to look upon state prosecutors with favor, as they do not work with them on a regular basis and are not in the same legal community. Finally, moving the case to a federal court would give Mark Meadows one final bite at the apple. Even if convicted, he could appeal in the federal court system, where there are conservatives peppered throughout, with the final say resting with the very conservative Supreme Court. So needless to say, Meadows and 4 other alleged co-conspirators want this case in the federal system. We know other Trump co-defendants want their cases in the federal system because 4 of them have appealed to the federal court for removal from the state. But Meadows was widely seen as having the best shot of winning this motion to remove. Even Trump's own counsel have flirted with the idea in writing of removing the former president's case to the federal system. But even his chances are seen to be narrower than Meadows' chances, simply due to the very fluid nature of Meadows' job. Therefore, this loss for Mark Meadows portends a loss for the other 4 cases, and presumably Donald Trump's as well if he were to file. It is important to note that the federal court is very rarely asked to remove a case from state jurisdiction. So this was a Hail Mary pass, to say the least. And just like most Hail Mary passes, it failed. Well, why did it fail? Well, I believe it's always important to know who the judge is in any case. Judges are people just like anyone else, and their experience can color their judgment. The judge in this case is federal judge Stephen C. Jones. Judge Jones is a Georgia judge through and through, receiving his undergraduate and graduate degrees from the University of Georgia and practicing his entire career in Georgia. His background is pretty boring, almost bland, which I suspect was a big favor to him in his confirmation hearings, as he was appointed by Barack Obama and approved by the U.S. Senate in a vote of 90-0. Like I said, boring. But being boring and generally seen as a by-the-book judge, and I suspect aware of the political sensitivity of this case and its profile, the judge took an unusual step and in the denial of the motion of removal wrote a 49-page opinion to accompany his judgment. An opinion of this length is highly unusual. Even more unusual than the motion itself. But he did it, I suspect, to avoid even the appearance of bias, something that personally gives me reassurance about the judiciary in general, and this jurist in particular. In this opinion, the judge explained that in order to qualify for removal, Mark Meadows had to prove that the actions that are alleged in the state's indictment were all in the normal course of action in his actual job as chief of staff in the White House, and were not political in nature. The distinction is very simple. Let's say you work at a construction company as a roofing supervisor. Your day job is to watch and manage the employees, set schedules, inspect the work, and manage the materials. But let's say your boss suggests that you attend an event at night with a large concern that is putting together a major construction project. He encourages you because one of the founders is from the town where you grew up, and he thinks that it would make a good impression. Now, the first part of your job, where you're managing roofing construction, is directly in line with your day job. It's in the job description, and all the activities directly associated with roofing are within the direct scope of your job. However, the smoozing and the glad handing after hours, while they might affect your long-term evaluation, you're not being paid for that. It's not in any job description, and it's certainly not within the direct scope of your job description. It's therefore extracurricular and therefore political. The judge went action by action through the activities the prosecution alleges and explained how all of these activities, except one, were political in nature and therefore not subject to protection under federal law. Just for the record, this is the law. If you work for the federal government and you are operating in your capacity as a federal employee, then your actions are protected by federal law and subject to the federal court system. But if you act in a political capacity under the Hatch Act, then you're basically on your own. That's what the judge ruled here. Now, as with any Hail Mary pass, there's a lot of fallout from this. First, on the negative side, Mark Meadows, in order to make this claim in federal court, had to get on the stand and testify. That's right, he had to swear under oath and testify. Now, that's a very high-risk decision for a number of reasons. First, his testimony in federal court is admissible as evidence against him in state court, which means that now, for better or worse, he is locked into a story. He cannot change it or contradict it in any way. Second, it gave the prosecutors of Fulton County a free bite at the apple. They already got a chance to cross-examine him under oath, so for them, it's a double benefit. His motion was denied, and now they know everything he will say in his state case and how they can use it against his other co-defendants. Third, and finally, now he has no leverage, or very little leverage, for himself to cut a deal. Because he's already testified in open court, now he has nothing to give the prosecution. They now know everything. So his use as a cooperating witness is highly diminished. But there are some benefits, huge benefits, to Trump, but perhaps not to Meadows. Meadows will most assuredly appeal Judge Jones's decision. This appeal will take months. If the other co-defendants apply for removal from the state courts, then they too may also appeal. Their appeals will take months as well. Now, the appeals may run concurrently through the federal system, but they may not. Regardless of how that goes, it extends the timeline. Furthermore, this case has 19 co-defendants and 150 witnesses, plus one other defendant, Kenneth Chesborough, a lawyer, has a separate trial. That means that this trial will take a minimum of 4 months to prosecute. It is now September. If all the appeals for removal take 5 months and the case itself takes 4 months, that puts us in June of 2024 in the thick of a presidential election. If Trump is the nominee, which all polls in the Republican Party indicate that he will be, there will be tremendous pressure on Fani Willis to delay the trial. If the trial is delayed, the real jury may just be the American people, as a sitting president is immune from prosecution. So the jury Trump and his co-defendants might have to ultimately answer to might be you. Yes, you. Watching this video right now. Hey, if you like this video, please like and subscribe. Please hit that notification button. I do put a lot of work into these, and I love your comments. I love your questions. So if you have any, drop them in the comments. And I just hope you keep watching. So take it easy. Peace.